I do think civility is underestimated. And by that, I mean that it's not only something that is expected of us by our profession, it's good for us. Judges appreciate civility. Juries appreciate civility. The clients appreciate civility. But civility allows you to have conversations. And, if you get into a good relationship where there's mutual respect and trust, I often, if I get brought into a case, I'll call the plaintiff's lawyer, or if I'm the plaintiff, the defense lawyer, and say, look, let's figure out what we can do informally. You've always got the right to quality control check it, with a deposition if you want. But, I'm all for getting it out there and seeing what we think of the case and getting to that point as quickly as we can. When you've got civility, you've got a much greater chance to have that kind of honest broker relationship.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm thrilled to share part 3 of this conversation with Clem Glynn. You talk about robots, and one of the things that is very top of mind right now is AI, generative AI in particular, and how that may be reshaping how cases are staffed, how law firms are staffed. Mm-hmm. Have you and your partners had any conversations or done any sort of evaluation as to what the future might look like a year, 2 years, 3 years from now with that on the horizon?
More conversations than planning. But it's probably among the, so I'm 51 years into the practice. I don't practice because I need to. I practice because I like the people I'm with, and I like being relevant, and I like solving problems, and I suck at golf. But I really do have some of the technology resistance or allergy to learning certain new things. It's pathetic, but I really do feel that probably describes parts of me. For example, I don't text. I can, but I don't want to be typing with my thumbs and all that. So I don't. And people, especially younger people, including my grandkids, it's like, you don't text. What is this?
Are you able to communicate with your grandkids? I don't know that I can communicate with my children if they're out of the house without texting.
No, I can. And they're really good. They're a good bunch. But I do sense that. So it's a long way of saying that probably the AI decisions are not going to be made, or certainly not designed by me. I'll do what I have to, but if at some point I have to learn too much, then given my estimated lifespan, I don't think I'll want to do that. But, what'll happen is I still to this day, I don't set up my own Zoom calls because I've chosen not to learn. And it's stupid, but I just say, hey, could you come in and, could you set up a Zoom call with Miles at such and such? And then they do it. So I suppose when AI comes, I can say that to the robot, hey, could you, but the idea that briefs may be written by robots is frightening to me. It's repugnant to me. And that again is maybe get off my lawn, grandpa talking.
I don't know that it is.
Oh.
I think that there are ways that I have seen foreshadowing where the legal practice may improve. We may have more opportunities to do the fun parts of our job.
Yeah.
Nothing is going to replace your evaluation, your conversation with that woman at the mediation. Mm-hmm. There's no bot that can do what you did there.
Yeah.
And building discovery shells and taking information from client documents and putting it into special interrogatories. Nobody likes that.
Right.
No paralegal, no junior associate. Yeah. And if there's a way to make it so that is easier and we can do higher level, the most fun parts of our job.
I get your point, and that makes sense. I've heard people talking about, even in my shop saying, they might be able to write a better brief. I mean, but if the AI is doing the case research, et cetera, I mean, and then I don't know, do you get comfortable and say, well, if the AI read the case, then I guess they got it right? Because reading cases is an art.
I mean, there's that New York incident that is, I think it was 2 or 3 years ago at this point. A New York lawyer in an aviation case was dealing with, I think it was a 12b6, a dispositive motion. And he used AI to write the brief, got some case citations that were really good for him in this case. So good that he asked the AI, are these real cases? The AI said, yes, they're real. He didn't go and look for them, though. And but the judge did. And the Article 3 judge was not particularly pleased when there were cases being cited that were complete hallucinations. They didn't exist.
Really? So Hal, from 2001. Yeah.
So I think that you're right. There are ways it will make light lifts easier. Why do we need to look up the standard for summary judgment and write that boilerplate? I mean, you're cutting and pasting it from a previous question anyway. But that won't stop us. If you're signing your name on it, you own it.
It's certainly a function of my life experience, including my early days in journalism, where I have a reverence for the words. And I mean, I love writing briefs. The art of a brief is not just a clear sentence, but it's what goes where and what doesn't even make it. How do you develop a theme that works and doesn't have distractions in it? I mean, for me, the hardest thing is to squeeze out all the extraneous stuff that when I start might be in my brief. I start big and come down usually, but we'll see. I think I'm not against the AI. I don't own any Bitcoins and don't want to understand that world. But, probably Bitcoins are a good thing. The new president says so. So there you go.
It looks like that is the direction that we're headed.
Yeah.
Are there any points of wisdom, cases, experiences that you feel would be beneficial for our listeners to know?
Depends who the listeners are. Well, I think one subject that is really important, it's important to ABOTA, but it's important to the state bar, is civility. And, on the one hand, discussing civility can be virtue signaling, right? Oh, yes, I'm above, we've all seen that. And, since sometimes when you see somebody else who's in ABOTA or American College or whatever, and that civility is emphasized by both organizations, you say, that son of a bitch is in here, that kind of thing. So we all know that. And there's probably people who said it about me, like, that guy, what a jerk. Because even though I believe in civility and I start with that as my assumption, my default, let's be adults on this case. If somebody is a nasty SOB and wants to take it to the street, then we'll return fire. We're not going to cross lines, but we're not going to curl up in a ball and say, oh, well, can we talk about civility? Because there's certain people that aren't going to talk or practice it. But with that introduction, I do think civility is underestimated. And by that, I mean that is not only something that is expected of us by our profession, it's good for us. Judges appreciate civility. Juries appreciate civility. Juries, they might like to see a good cross-examination of a person who's inherently dislikable or who they've grown to distrust as they hear him or her testify. But by and large, the confrontations that we, dream about, those the Perry Mason moments. Jurors are uncomfortable with a lot of that stuff. They just want to know, what do I need to know to decide this case? Don't give me drama. So those are your audiences. The next is the clients. If you are, if you're a discovery game player, what are you going to do? You're going to harden feelings, make the case more difficult to settle, and drive up the cost of the case dramatically. I mean, discovery is the most wasteful part of what we do many times because of that. There's people, I used to work with a lawyer he'd go through all the documents himself, not in my firm, but he was a lawyer at Pillsbury. And he had 3 tiers, first wave production. Next wave he produces as if there's, emotion. And then, then the hot docs that, he'd die for, they're all responsive.
Wow.
But he put up these doors that you had to get through. And I thought, God, what kind of crap is that? So clients appreciate civility. There are clients who want a junkyard dog, unless it's a woman, and then they don't want it because they think that's unseemly, right? That's one of the great double standards. My lawyer's a junkyard dog, and then if it's a woman, oh, what a bitch, that sort of thing is still around, but much less so than it used to in my experience. But civility allows you to have conversations. And, if you get into a good relationship where there's mutual respect and trust, I often, if I get brought into a case, I'll call the plaintiff's lawyer or if I'm the plaintiff, the defense lawyer, and say, look, let's figure out what we can do informally. You've always got the right to quality control check it, with a deposition if you want. But, I'm all for getting it out there and seeing what we think of the case and getting to that point as quickly as we can. Because I'm oriented to try to solve the problem. I've never tried to keep a file alive, for economic reasons. I want to win by getting it done. Not necessarily by conquest, but just let's get it resolved, because we're going to resolve it. Probably 8% of the cases are going to get resolved. So doing it earlier is better than doing it later. And when you've got civility, you've got a much greater chance to have that kind of honest broker relationship. And the other thing is, every lawyer has experienced an opponent who you just don't want to deal with. When I see his letters or his emails, you don't want to talk to him or her on the phone because it's going to be so nasty and so unpleasant. And even if you can withstand it, it's like, who wants to spend part of their day dealing with that kind of arrested development case? Because it usually is. There's no rational reason to be that way unless you're being mistreated yourself. And then conversely, oh shit, that's Miles on the phone. We're probably going to talk about one of his podcasts before we even talk about our case together. To me, the friendships and the relationships that I've been able to make over the arc of a long career is probably the most, it's right up there. It's one of the 2 or 3 most gratifying parts of being a lawyer. And to this day, if I'm drawing a blank on an expert, I'll call plaintiff lawyer friends of mine and say, here's the kind of case I got. I can give you a name, but I didn't give it to you, that kind of thing, So there's a utility in it in addition to everything else. So in one sense, it's harder for young lawyers to have that vision because they're coming of age in the profession. They want to show they know what they're doing. And so sometimes they think, well, the only way to really do that is to be tough. But there are young lawyers who are very good at recognizing that professionalism and civility are not signs of weakness. They're signs of confidence, And smart lawyers know that, and on the receiving end. So, and when I see a lawyer who's young and has those traits, I'm immediately like, okay, well, this is somebody I don't have to get to the next level up. I can deal with this person. This is a smart person. So I think that's a big part of the future of our profession.
I'm smiling a little bit because I think back to when I was a young lawyer and drafting letters for my mentor, Cynthia McGuinn.
Oh, okay.
And having her rewrite them multiple times because, and telling me, I understand that's what you think a lawyer should be doing, but that is not how we approach this. Yeah. And whipping that civility into me.
That's a lesson over a lifetime of this. And, again, I don't want to virtue signal. I'm sure I've had my moments because I've got a good Irish temper, but it ain't like it used to be. And I don't want to get political here, but we have a lot of things that are new aspirations in our culture on the part of some that other people think, oh, come on, you're just virtue signaling. And I think it would be easy for people to think that's what the profession's focus on civility is about. And I think that would be a mistake. And civility as a part of being a lawyer is all good. It's not a trade-off. It's all good. You get more flies with honey than with vinegar, they tell me. I've never tried either. And it's just true. It's just part of human nature. Think about the average litigating lawyer, whether he or she's in a big firm and they think that they're just godlike creatures, or in a small firm or medium-sized firm. What is common among most litigators? If they are aggressed, they aggress back. If somebody aggresses, they raise the ante. I'm tougher than you are. I'm not intimidated. Now what have you started? You've started a forest fire. And whereas civility has the opposite effect. As I said before, it allows you to have a conversation.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. You mentioned having an Irish temper that may not flare as much as it used to. Do you have examples of, because I can think of times where I espouse civility, I try to do my best, and I'm not always perfect. And how have you course corrected when you've had, we'll just call it a failure in terms of an engagement with the other side?
I don't know that I have kind of lost it and then said, oh, God. But there may be times when I was severe, but just, they deserved it. So nothing to apologize about. But my pattern, like, for example, married for 56 years. And my pattern always has been to kind of go up fast if if something gets to me the wrong way, and I get, and then come down very quickly. And I think I've always maintained, I got a great wife who's never going to let me skate if I try to, but I always try to look, okay, was my behavior over a line? And if so, to acknowledge it, to own it. And if I have done it in the profession, and it sounds silly to say I've never done it, but I can't think of a time where I was mortified, where I said, oh, geez, I should never have done that. Oh, God, I lost my cool. I'm usually able to maintain my temper professionally. Now, on the basketball court, that was probably not always true. I used to play in the Bar Association League every year when I was at Pillsbury. We had a good team, and we were always trying to get to the finals, and sometimes we get semis, sometimes we get to the finals. And one night we were playing the DA, I think it was the DA's team, and it had Gordy Baranko, Leo Dorado, who both became judges, both great basketball players. Perker Meeks played for him for a while, later in PD, and then became judge. And I think it was in that game. Anyhow, for some reason, Ira Brown was there. And Ira Brown was the former law and motion judge for years in San Francisco, and an interim judge, really smart, really didn't suffer fools, and had shibboleths that, if you came in wearing a raincoat, he would just light you up. And
I've heard stories of Judge Brown. He preceded me.
Yeah, he was a big man. He was very heavy, and it was kind of like he didn't raise up, and so he intimidated the hell out of me because I was a young lawyer. He was on the bench when I was a new lawyer, and we were playing Thielen, and that was his old firm, Thielen, Marin, Johnson, and Bridges, and Brown is in the stands, and I take one on the end of my pinky and dislocated it. It was like right angle dislocation. I'd probably drop in a few F-bombs, and they had to go to the hospital, I think SF General, where they set it and all that. And I had to appear the next morning in his courtroom, and I was thinking, oh, God, he saw me at my worst. and instead of him having some sort of scolding that he felt he had to give me, he asked how I was, just very, human to human.
Yeah.
And it was a good moment. I said, I held it up, said, no, it's pretty good. But I would say more in the athletic contest than in the legal contest. Would there be occasions where I would say, I kind of lost my crap there, didn't I? But I'll think about that because it's a good question. And maybe the fact that I don't remember them tells you a lot about me. Less about my civility and more about my ability to compartmentalize, as I told you earlier.
I think, though, I've come across lawyers who don't rise. I know that I have risen on occasion, particularly in depo. I've snapped, and then I try to apologize as quickly as I can.
Yeah. Well, you got the voice for it, though. That's the thing.
Clem, I've really enjoyed our conversation. Is anything else that you feel that we should cover before we wrap up?
I was telling somebody this story recently because I have had a few Perry Mason moments. The one that I remember most vividly, I was trying a case for Chevron out of the Richmond refinery. So not a popular client. And the plaintiff was a woman who was an alleged safety whistleblower who claimed she'd been terminated for blowing the whistle. So dangerous case.
Mm-hmm.
Her lawyer was not civil. He's still practicing. I look him up every now and then. He's a young guy, big guy. And so when he's taking depositions of my people, he's literally leaning, his face is bright red, and he's leaning across the table. He had a big booming voice, not a good mellow voice like yours, but a booming voice that came out of his chest and just trying to intimidate. So I'm sure I said some things to him, but I don't think I owed him an apology. Anyhow, so we go to trial, and the plaintiff was in charge of what they call turnarounds at the refinery. That's when they shut down major vessels and they come in and they weld and they clean and they refurbish and they replace parts and so forth. It's a big deal. They bring in massive amounts of people to do it so they're not down, production's not down any longer than necessary. Her job was to oversee the independent contractors who came in and just crack the whip. And it was a completely male-dominated world, the refineries, and they wanted more female participation, and she fit the bill perfectly for this. She's a tough cookie. And so despite her having to make sure that the contractors towed the line, she persuaded some number of them to come to her home one weekend and move about 40 yards of topsoil using some of the heavy equipment that was on lease to Chevron for the turnaround. This was found out about. It was a clear violation of conflict of interest policy. The head of HR told her boss, who loved her, she's got to go. Her boss said, no, I can't afford to lose her. I need her. The head of HR says, we either have a conflict of interest policy or we don't. If we don't terminate her, our policy is meaningless. It's not a progressive discipline kind of case. So he continues to internally fight the battle for her. And his son, in the midst of all this, suffers an accident. I don't know, it might have been a bicycle accident. And he had a serious head injury. And he's in the hospital. And the dad, this woman's supervisor at Chevron, is at his son's bedside, and he gets a call. You got to get down here because it's about to go down. And if you're going to try to do anything, you're going to have to be. So he leaves his son, he was worried about, and goes to the refinery and is ultimately unsuccessful, and she's terminated. She complained about everything. That was part of who she was. So she did have some safety complaints in the long list of things she complained about so she could piece together the story. It was not why she was fired. And so she makes the huge mistake of suing both Chevron and her supervisor, guy who would fight for her and did. And she wrote it up. I can't remember the language anymore, what the particular point was, but she attributed to him things that were completely false. And I knew this. And I had a way to prove it. And so I've got her on the stand on cross-examination. So the first time I formulated the question, I read that part of the report, and I said, now, Miss So-and-so, when you said blankety blank, That was not correct, was it? Well, and just this long, non-responsive answer. So in certain instances, you have casting that you didn't create that allows for dramatic pauses. So I look over at the jury and they're kind of looking down. And so I escalated the question. Miss So-and-so, when you said, and I read it again, that was untrue, wasn't it? Blah, 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 blah. So it was Judge Berniers I went to the DCA and I said, Your Honor, would you please instruct the witness to answer my question? Miss So-and-so, you need to listen and answer counsel's question. So this time I took the question up a notch. Miss So-and-so, when you said, and I read it again, that was a lie, wasn't it? And she knew she had to, and she says, yes, but that's the only time I lied.
Wow.
So the case was pretty much
Wow.
over. Yeah. So those are the moments we dream about. And she was a bad person. This wasn't a jump ball case. She was a liar. And the whole case was a lie. And she was so viperous that she attacked a guy who had left his son's bedside to go to bat for her.
Wow.
Yeah. Evil.
Well, thank you very much, Clem, for taking the time to sit down with us.
It's my pleasure.
Yeah.
Enjoyed it.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.